lays down the foundation of our government, defines the rights and duties of citizens, and sets the framework for our collective journey towards justice, equality, and liberty. Every year, on November 27th, we celebrate the adoption of the Constitution of India. It was on this very day, 1949, that the framers of our Constitution, with their signatures, giving shape, guiding principles that would govern our great nation. It's a reminder of our shared commitment, the ideals enshrined in this remarkable document. It is a day to reflect on the values that bind us together as a diverse and vibrant nation. In the spirit of intellectual exchange and dynamic dialogue across the that is, Indian Constitution and social justice issues and challenges of laws, PNS, PNSS, and PNS. Now, let me introduce you each another international business, an institution of repute that empowers citizens with a valuable platform for growth. Established in 2004, GIBS is affiliated with Guru Gobind Singh and from the All Indian Council for Technical Education Program, as well as Bar Council of India for Law Program. The Institute offers an array of programs, including MBA, MBA International Business, MBA Integrated, BBA Honours, Integrated BA LLB Honours, and Integrated BBA LLB Honours, along with an MPhil program in corporate law, constitutional law, and alternative dispute resolution. GIBS has been consistently recognized for excellence. Grade A by exam in its third cycle, rated A+ by the State Fee Regulatory Committee under the NCT of Delhi. Highest rating of A by the Joint Inspection Committee of the Government of NCT of Delhi and GGS-IPU since 2013. It is grade A by the Academic Audit Cell of GGS-IPU since 2011. Established in 2017, the Legal Aid Clinic and Center for Legal Studies, Uttarakhand International Business School, aimed at empowering the oppressed and providing solutions to their problems by using law as a tool for social engineering. The Legal Aid Clinic at GIBS acts as a bridge between legal aid and poor, oppressed, PNF, PNSS, and PSA. We have a distinguished panel of experts over here, and now I would request Honorable Director Sir to introduce our audience to the learned panelists.
Thank you, Srishti. I hope I am audible. Can you unmute me? Accredited Mediator and Advocate, Professor Maheshwar Singh, National Law University, Delhi. Constitution Day or Samvidhan Divas is celebrated annually on November 26 to honor the adoption of the Indian Constitution in 1949. Drafted under the visionary leadership of Dr. B.R. Ambedkar, the Constitution lays the foundation for India's democracy, upholding ideals such as justice, equality, liberty, and fraternity. Dr. Ambedkar aptly noted, justice has always evoked ideas of equality, emphasizing the judiciary's critical role in realizing these values. The judiciary, as the guardian of the Constitution, plays a pivotal role in ensuring these principles are upheld. It not only interprets the law, but also protects the rights of all citizens, particularly the marginalized groups. Social justice, a cornerstone of the Constitution, aims to create an equitable society where resources and opportunities are accessible to everyone. Through landmark judgments, the judiciary has consistently advanced this vision. In Keshavanand Bharati versus State of Kerala, the Supreme Court established the basic structure doctrine, ensuring that constitutional values remain inviolable. Cases like Vishakha versus State of Rajasthan, which addressed workplace harassment, and Navjot Singh Sidhu Johar versus Union of India, which decriminalized homosexuality, showcase the judiciary's proactive stance in fostering social equality. Public interest litigations have further expanded access to justice, empowering citizens to raise collective grievances. Justice D.Y. Chandrachud once said, "The judiciary must not only uphold the Constitution, but also act as a shield for the voiceless, reflecting its role in democratizing justice. Recent legal reforms have marked a significant shift in India's legal framework. 3 new laws aim to modernize and align legal system with contemporary needs, which we'll be discussing during this Constitution Day. 1. Bharatiya Nyaya Sanhita 2023. Second, Bharatiya Nagrik Surakshita Sanhita BNSS 2023 and Bharatiya Sakshi Adhiniyam BSA 2023. These laws signify a shift from the colonial era framework towards a system that aligns with India's aspirations. The judiciary's role in interpreting and implementing these changes will be crucial in fostering social justice and protecting constitutional values. Understanding the importance of Constitution Day, today we have some eminent personalities who will be acting as the panel members for discussion on the topic. I now take the opportunity of introducing our esteemed guests. First, I take the opportunity of introducing Honorable Justice Rajesh Tandon ji. Justice Rajesh Tandon sir was appointed Additional Advocate General on 5th September 2003. Sir took oath as Judge of Uttarakhand High Court on 3rd July 2003 at Nainital. His remarkable achievements are: he was elected twice as Vice President of High Court Bar Association, Allahabad. He is a member of Advocate Association, Allahabad. Sir has also been ex-Vice President of Uttarakhand Bar Association. He is also Executive Director of Indian Law Institute. He has been arranging seminars under the auspices of Vidhi Vichar Goshti Nainital for the last 34 years. I take the opportunity of welcoming you, sir, on behalf of our Honorable Vice Chairman, sir, Shri Anirudh Jindal ji. Welcome for this panel discussion. I now take the opportunity of introducing Mr. Anupam Goyal, Judge District and Session Court, Delhi. Sir is Principal Judge in Family Court of Muzaffarnagar. He joined HJS on 15th December 2008. Sir has did his doctorate in the year 2002. He has also been conducting various training programs. Some of these include National Orientation Program for newly appointed ADJs at National Judicial Bhopal, refresher training for additional district judges under 13th Finance Commission scheme at IJTR. Sir, I welcome you for this panel discussion on behalf of our Honorable Vice Chairman, Shri Anirudh Jindal ji, and myself. I now take the opportunity of welcoming Ms. Puja Anand, internationally accredited mediator and advocate. In the year 2009, ma'am started her active career as mediator in the Honorable Supreme Court of India, Delhi High Court and District Courts. She did her first certification in 2006 from Dallas University. Ma'am has been appreciated for her role as mediator in many judgments of the Supreme Court and High Court for her commendable work. Ma'am, I take the opportunity of welcoming you for this panel discussion. I now take the opportunity of welcoming Professor Dr. Maheshwar Singh, National Law University. Dr. Maheshwar Singh is a professor of political science at the National Law University, Delhi. Professor Singh has been teaching political science and international relations for nearly 2 decades. He has been with NLU Delhi since 2009. He holds a doctoral degree in diplomacy and international security from Jawaharlal Nehru University, New Delhi. Sir is also the Director of Center for Studies in Disability and Law at National Law University, New Delhi. He has been visiting professor at a number of universities in Europe. Sir has researched and published in the areas of water laws, disability laws, and policy and development induced displacement. He also works as a consultant to prominent institutions of the government. I welcome you, sir, for this panel discussion. We are now set with the eminent personalities with us for the Constitution Day being celebrated today at Geetarathan International Business School and across the country. I now ask the host to take on the platform from here and let's move and listen to the eminent personalities. Thank you very much.
To both teachers' education and societal betterment. So thus, please take over the panel system.
Thank you, Srishti. Good morning, distinguished guests, honorable guests, esteemed advocate, and respected Professor Sir. We gather today to celebrate the Constitution Day, that is, Samvidhan દિવસ, making the adoption of Indian Constitution on the 6th November 1949. It is a moment to reflect on the constitutional unparalleled upholding the democracy and social justice. Our topic for today's discussion, that is, Indian Constitution and social justice, issues and challenges of new laws, centers around the three significant pieces of the legislation introduced in 2023. The Bharatiya Nyaya Sanhita, BNS, Bharatiya Nagrik Suraksha Sanhita, BNSS, and Bharatiya Sakshi Adhiniyam, BSA. These laws bring far-reaching reforms in the criminal justice, but also raises the critical question regarding their impact on the constitutional principle and societal equity. Today, we are fortunate to have the distinguished panel with us. I am honored to introduce them. Firstly, we have Honorable Justice Rajesh Tandon sir. He was appointed as an additional advocate general on 5th of September 2003 and took the oath as judge of Uttarakhand High Court on 3rd July 2003 at Anand. He further took an oath as a judge of the High Court of Uttarakhand for today's discussion. We welcome you, sir. Next we have Mr. Anupam Goyal, sir, Judge, District and Session Court. He has been serving as the principal judge in the Family Court of Muzaffarnagar, and he has joined the Haryana Judicial Service on 15 December 2008. He holds a doctorate and has been instrumental in conducting various training programs, particularly in the areas of family law. His unique expertise as a practice judge will be crucial to understand the challenges these new laws might face. We welcome you, sir. Next, we have Senior Advocate Puja Anand, Honorable Supreme Court of India. In 2009, Ma'am started her career as a mediator in the Honorable Supreme Court of India, Delhi High Court and District Court. She has been appreciated for her role as a mediator in many of her judgments in Supreme Court and Honorable Delhi High Court for her commendable work in alternative dispute resolution. Her experience as a mediator offers a valuable dimension to today's discussion on justice reform. We welcome you, ma'am. Next, we have Professor Dr. Maheshwar Singh. He is a professor of political science at National Law University, Delhi, and has been teaching political science and international relations for nearly 2 decades. We welcome you, sir, on board. Now, with the permission of this bench, let us now begin with an insightful exploration into the impact of Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Sakshi Adhiniyam. Moving forward, I will now start the questionnaire round firstly with the Honorable Justice Rajesh sir. The Indian Constitution remains a beacon of hope for the marginalized communities, guaranteeing the rights through its commitment to equality and justice.
Then we have the Constitution, which was of 1950. The Constitution contains an elaborate idea of fair justice and right to livelihood, right from Part 3 of the Constitution, that is Article 21 of the Constitution.
I would emphasize that on the one hand, the question of rights become very important, and everyone talks about right to this, that, and the other. All right. No one talks about the duty, all right, which is enshrined in Part 4 of the Constitution. Starts with Article 51A. Duty performed, or duty to be performed in pursuance of those rights. The father of the nation, Mahatma Gandhi, once said that every duty performed creates a corresponding right. All right. So my emphasis is, even if the Constitution is equipped us with a sense of right, a sense of sense of ourselves, to realize that we need to perform duties which is enshrined in the Constitution as citizens of this country. I think I'll restrict myself to that in my opening remark and give the floor to my other fellow panelists. Thank you so much.
Thanks a lot, sir. We are honored to have you as a panelist today. Next, we have Mr. Anupam Goyal, sir, Judge, District and Session Court. I would like you, sir, to speak on today's topic, sir.
Yeah, Honorable Justice Rajesh sir, I'm the panelist. I feel privileged to be present in this important discussion. As this topic is revolving around these three laws, new laws have come, BNS, BNSS and BSA. They are just precursors of these laws for IBCC and BCA, which we all know, with certain amendments which were required by the present time. These laws have come. Now, these laws mainly focus on criminal justice system. I have a very long experience of handling the criminal cases. So far as this point, that Constitution and its institutions can thrive only when our legal system is effective. I am seeing, it is my experience as a judge and as an individual, that deterrence in criminal law is losing. It is very less. So we are having crisis in criminal justice system. Why there is so much deterrence? When our democracy is thriving, but deterrence is not there. I think we are a rare democratic country where we see in last couple of years, we see several instances where a person is killed by being cut into pieces. Can democratic countries see this? And despite there is no fear of law. When there is no fear of law, I think two reasons are there. There is no respect of law. And at the part of individual and at the part of public authorities, there is problem in implementation of those laws. These three laws have come. We think we should strive towards making them effective. And I have 2-3 suggestions. I think my respect of law is very less in individuals. I think that it is offshoot of two factors. There is little respect, rather disrespect of several institutions. In families, we don't think that our parents are inculcating sanskars, and I'm talking of masses, not few families. Inculcating sanskars in their children. If families are witnessing, there is no respect for elders, even no respect for parents. In schools, teachers, universities, I see there is no respect for teachers, and there is no respect for public authorities. So far as marginalized sections of society are concerned, I think I should take it in some broader perspective. A person who is in marginalized position, he is also part of our society. For example, if we see some in this rainy season, there was an incident took place in Tandon. One girl was going on the motorcycle, and the water was falling. It was raining, and some 4 or 5 persons there and mistreated her. So she was in marginalized position, I think. As Lordship said, that right to live with human dignity is fundamental right. It is for everyone. If we see some years before, an incident took place in Palghar when 2 Sahus were killed, though they were in police protection. they were in marginalized position. Sometimes I feel, I go to sacred place, to river, to see some temples. This band of persons are there after me to give some alimony or to harass me. That harassment is also a mistreatment. I feel, even as an officer or as as educated person, I come out in public. Sometimes I feel less degree of mistreatment by fellow countrymen. So I am in marginalized position. So why is this so? It is so because there is no respect of law or disrespect of law. Nobody wants to follow them. And I think it is due to some sanskars, proper sanskars are not being given by your family or by our, in our institution, schools. Sure, there may be some other reasons also. So I think that this constitution can thrive only when this in individuals, in masses, respect for law is inculcated. Now, I am coming on implementation part. The implementation, if democracy can thrive only when implementation is very strict. I am not saying high-handedness at the part of public authority. I am not saying so. But there has to be balance. If there is high-handed, okay, a public authority can punish. But its hands should not be restricted. Unless implementation of these laws. So I think effective implementation of law can only further achieving the goal of constitution and constitutional goals. Thank you.
Thank you, sir. Thank you for putting highlights on the importance of the constitution law. To give some views on how does the Indian Constitution uphold the social justice for marginalized communities, and what, in your esteemed opinion, sir, are the primary challenges or the limitation in translating its ideas into practice? Honorable Justice Rajesh, sir, I would like you to give your viewpoints on this.
Sir, you have to unmute yourself.
सर एक बारी फिर से बोलिए, प्लीज अनम्यूट योरसेल्फ.
Sir, you have to, sir.
Tandon sir, you are mute. Please kindly unmute yourself.
Yeah, now it's fine.
Yes. Now, yes. In the very beginning, when I have given my lecture, then I have stated that our 3 apps which have come up, new apps, have taken the ground and it has become a completely digital evidence. If you look to the Information Technology Act, right from Section 4 onwards, the entire electronic record is a primary record now. It has appeared in the Saksh Adhiniyam, Section 54 has stated that the primary evidence will be the digital evidence, electronic evidence, and therefore the whole complex of the constitution, that is right to livelihood, is now proceeding on the digital evidence, electronic evidence. Therefore, right to livelihood has now been confined, that is, a dignity has been confined to Article 21, and that is going on the electronic and digital evidence. Even online programs, we are here on the online program. Every program is now proceeding online, and that has become a part of livelihood now. Because what we have to live on online, digital and electronic evidence. These are all the fortunes of the Constitution. These are all the significance of the Constitution, and these are all the preambles of the Constitution. Now, therefore, we must thank to Constituent Assembly that Article 21, right to live, has been given in the form of where it now online, digital, or whatever may be, but it it is a right to live. We are here as a right to live, and therefore the judgments of the Supreme Court taking into consideration the Khadak Singh judgment, Kapilani Gowari's judgment, all these judgments talk about right to livelihood, that is universal declaration of human rights, as well as protection of human rights. All those have assembled, and now we are in the wave of digital, electronic, and right to livelihood under the protection of human rights. Everybody has got dignity of his own, and dignity continues right from preamble of the Constitution and also from protection of human rights. These are all my submissions, and let's proceed on the question answer.
Only fighting the legal battles, but also shape the public understanding of justice and rights. Ma'am, how do you see the role of advocates in ensuring the social justice as embraced in the Indian Constitution?
Thank you very much for this question. As I said, that I am a practicing lawyer since 1994, and I had a very good fortune to be, with one of the best person who could teach me. So I would say that yes, the Constitution of India does guarantee fundamental rights, including the right to equality, right to life, personal liberty, and the right to freedom of speech, among others, which form the bedrock, I would say. But like what Honorable Justice Tandon said, that rights have to collate with duties. There are directive principles enshrined in our Constitution besides the fundamental rights. Now, as advocates and as officers of the court, our role is to act as critical instruments in upholding these rights and promoting justice for marginalized and disadvantaged communities. So when we say that the first, I would just like break it up, the roles of the advocates is protecting fundamental rights. Advocates are essentially protecting and trying to, in a way, enforce the fundamental rights as enshrined and guaranteed under Part 3 of the Constitution. The lawyers, they represent individuals or groups whose rights have been violated by the state or private people, ensuring that justice is not denied. The judiciary is often, with the support of advocates, has played a crucial role in interpreting the Constitution. I would say financial standing can have an access to justice, including social, economic, and geographical barriers, not with overweight. The third, as a practicing lawyer, I see that public interest litigation, PIL, which has been very active since 1980. It has seen a sudden rise. It allows advocates to bring cases before the court on behalf of those whose rights have been affected, but who do not have the means or the capacity or the knowledge to approach the court. So PIL has become a very powerful tool for ensuring social justice to issues like the environmental protection, health rights, labor reforms. But the other role of lawyers is that they help in, they push for legal reforms that advance social justice system, that participate in framing and amending of laws, as has happened in the BNS, the BNSS, and the BSc. So it is like, they are it's like two wheels of judiciary and the legal fraternity, which frame and amend the laws and take the Constitution's commitment to justice, equality, and liberty through. So through advocacy, legal education, policy interventions, lawyers can help, shape the development of law in a way that aligns with the principles of social justice. For example, the abolition of untouchability under Article 17. Or the legal recognition of women's rights. There was a time when women were not permitted to take on the property, the assets of her family just because she's born as a woman. Now those things have gone away. So in a way, the advancement of the whole country, when we say that that country is very advanced, we are very backward. Why such things come into the mind is because there are certain laws which need to come into place, which can then show that yes, the people generally, the marginalized sections have advanced. Like in many of the cases, advocates have really played a very instrumental role in influencing judicial activism. They have been pushed boards to address systematic issues like poverty, caste discrimination, gender inequality, and there have been proactive measures by the Hon'ble judges to deliver social justice, especially when other branches of the government have fallen short of it. So advocates are often, as catalysts for activism. Besides that, advocates are also involved in educating the public about the legal rights through awareness campaigns, community outreach, and legal literacy initiatives. Besides that, as an advocate and as practicing advocate, I already said that upholding constitutional values which are envisioned social, economic, political justice framework is what advocates help to realize. So, by interpreting the laws, because laws, there is a law is like two sides of a coin. So, lawyers help in interpreting the law in a way that aligns with the Constitution's values of justice, liberty, equality, and fraternity, and they also help to contribute to foster an egalitarian society where justice is not just seen, but it's also felt that yes, it has taken place. So that I would say is the role of advocates. Thank you so much.
Thank you, ma'am. We can definitely say that the legal system is constantly trying to help the marginalized people. Recently also we have seen Justice Manmohan, Honorable Acting Chief Justice of Delhi High Court. He has been inaugurating the legal in India.
Well, I've already spoken about it. I'll further elaborate upon it. With due respect to Justice Tandon and my colleague Ms. Puja and the judge of Haryana District Court, Mr. Goyal, I would say that law does not operate in vacuum, alright? Law operates in tandem with, a legal system always operates in tandem with a political system, a cultural system and a social system. That's what my colleagues have been highlighting right from the outset. Me as a political scientist would look at the legal functioning, legal aspect of our lives from the person of political working of political and social system. If one were to sort of define social justice, then one would ask a simple question: which group in society, sort of needs the social justice most? All right, and from early modern period to modern period in legal theory, a number of proposals have been floated, all right, to address the question of social justice, all right. But none of the proposals are holistic enough, in the sense that there are communitarians, there are utilitarians, there is Rawls' theory of justice, there is Amartya Sen's idea of justice, and so on and so forth. Michael Sandel says that justice is the right thing to do, but what is that right thing that needs to be done? That is decided in a particular context. I'll take the example of women, all right. Now, all right? Nevertheless, women as a group, require 50% of the population is constituted by women. So they urgently, the social justice, any social justice manifesto urgently needs to address the question of women's empowerment in a country like ours, all right? Now, I was making a distinction between urban and rural women. We all know that ours is a caste-divided society, and women belonging to lower caste, suffer many multiple marginalization than women belonging to upper caste or women belonging to the urban areas. So therefore, women cannot be treated as a homogeneous group. Nevertheless, we need to address the question of we need to really think about how to address the question of justice raised by women. And as my colleague has rightly said, that the courts have pronounced judgments, all right, in which women are the co-partners with other siblings in a household in the family-owned property or family-earned property or ancestral property, all right. Likewise, take the case of, you have international conventions which sort of prevents discrimination against women. Take the case of people with disability, and they are the ones who deserve who rightly ask the question of justice. All right. According to 2011 census, almost about 3% of our population is disabled population. 3% of 1.4 billion people is staggering in numbers. They cannot be counted so easily, and they are invisible. All right. There is international convention to address the question of discrimination in youth because of disability, and we have a 2016 Act, all right, passed by the Union legislature to address the question of disability, and then rules within the Disabled Act is being passed by each state government. All right. So we can say that the traditional groups, for example, scheduled castes, scheduled tribes, the other backward castes, they require the question of, for them social justice is important, but within those groups, women form an important component. For them, social justice is equally important. Within those groups, people with disability form an important population component. For them, social justice, the requirement of social justice is equally important. All right. So then, what is the source of the social justice? If not our constitution and the interpreters of the constitution, which is the courts, and the officers of the court, which are the lawyers. But courts can give out judgments, but eventually it has to be implemented by the executive. All right. So therefore, a legal system cannot be seen in isolation, divorced from a political system or social system. They have to work. They have to be working in tandem, in consultation with each other, all right, for effective address of the question of social justice. I think that's what I will say.
Thank you, sir, for highlighting how the Constitution's vision translate into the education and awareness. You talked about the importance of raising women's status in India. He talked about the international conventions. Like we have international convention on the rights of persons with disabilities, which was adopted in 2006, which is an international treaty which aims at promoting and protecting the rights of a person with disabilities, including the women and the girls. And now, let us now come to our next panelist, Honorable Justice Rajesh sir. Judicial implementation plays a pivotal role in bridging the gap between the constitutional ideas and celebration laws. However, achieving the synergy between the two remains a challenge. Now, sir, how can the synergy between the constitutional provisions, laws, and judicial implementation be strengthened to address the social inequality effectively?
Yes, thank you very much. Much has been said twice by myself, but I will just add, since the question of artificial intelligence has started, I will just add 2 or 3 things which has destroyed the whole society of mine, as the advocate has also said this. Now, what is happening today? If you look to the Information Technology Act, Section 43. Section 43 provides penalty and compensation for damage to computer system if a person without permission of the owner or any person who is in charge of a computer system or computer access or secures access to such computer system or computer network or computer resource, everybody shall be liable to be punished. But what is artificial intelligence? It has neither been defined under the Act. It is coming up from the data. Data, what is data? Nobody knows what is data. If the person is under the digital arrest, how they are fooled? No law is there, nothing of the kind. There is no digital arrest like this under the Information Technology Act. There is no separate law for the digital or any other arrest or anything. But how the people are being befooled? Now the Act has come. Now the communication device. What is communication device under the Information Technology Act? That means all cell phones, personal digital assistants, or combination of both or any other device used to communicate, send or transmit any text, video, audio or image. The word image has also been used under the Information Technology Act. Why not the government is giving a knowledge of all these things, of the Information Technology and all these things? Why the people are coming under the garb of these images? The images which are coming up, they are being fooled. Now images are just images. They are not in reality. They are not in reality. And therefore, the law has to come, the punishment has to come. Whatever digital arrests are being going on, some punishment has to be done. Those things have to be defined under the Information Technology Act after getting it amended. That is computer resource. What is the computer resource? Nobody knows that. Nobody knows about the communication device. Communication device includes these images also. And those who will give the images, will be punished. And therefore, lot of amendments have to be made under the Information Technology Act, Data Protection Act, and all these things. All should be punished under the Criminal Procedure Code also, new CRPC, under this Information Technology Act also, because you know Section 66A has been declared to be null and void. That is under the Information Technology Act, that is in Shriya Singhal's case. But now that also needs a review review of the judgment, because all these are happening under section 66A, because the knowledge which is being given, which is being conveyed, all these things are covered under section 66A. Therefore, I will say that the Shriya Singh's case has to be revised and it has to be reviewed, because if you look to the section 66A, all these offences are covered under section 66A, but the digital evidence are being going on and digital arrests are being going on. Now, if you look to section 66A, you will see that it needs to be revised. Punishment for sending offensive messages through communication. Each and every word has to be seen through communication. Any person who sends by means of a computer resource or a communication device any information that is grossly offensive or has menacing character, any information which he knows to be false, but for the purpose of causing annoyance, inconvenience, danger. What is danger? Use danger, obstruction, insult, injury, criminal intervention, enmity, hatred, or ill will personally by making use of such computer resource or a communication device. Then any electronic mail or electronic mail message for the purpose of causing annoyance or inconvenience, or to deceive or to mislead the addressee or recipient about the origin of such messages. All these things are covered. What is the digital arrest? All are covered under section 66A of the Information Technology Act. Therefore, the section 66 has been made obsolete by deleted by the Honorable Supreme Court in Shriya Singh's case, and that has to be revised. I think the advocate of the Supreme Court also will agree with my views. I don't know, but that has to be revived, and that has to be reviewed, because all these arrests, all these informations, all these knowledge are being extended by the computer resource to the public at large. Thank you very much.
Your Honor, your perspective on aligning laws with the constitutional impact and effectiveness requires an academic inquiry and critical analysis. Coming to Professor Sir, what are the academic and the policy related challenges in studying and addressing the social justice issue in India? Professor Maheshwar sir, I would like your opinion on this view.
Certainly, there are the Constitution, and how it is sort of creating a distance between Jammu and Kashmir and the rest of the India. Alright. A knowledge fund was created. The issue was taken over and over and over and over again to the political parties. Alright. By the people. Alright. These political parties, as the opportune moment came, formulated an act, passed it in the union legislature, and subsequently an appeal was filed in the courts of law. In this case, the Apex Court. And Apex Court has stamped its legal sanction over the soundness of the application of Article 370. The second example, the second instance is that of how people play a significant role in how people are at the center of law making and law interpretation rehabilitation. Take the case of Relief and Rehabilitation Act. All right. So we all know it as a matter of fact that the Scheduled 5 regions of the which are described in the Constitution of India is a resource-rich region. All right. And so many heavy industries have come up in these resource-rich regions of Scheduled 5 areas. All right. And that has caused a development-induced displacement. So what happened to this displaced people? What will happen to this displaced people? The displaced people do not have the adequate education, do not have the adequate training to get hold of jobs in job market, all right, to negotiate for a job in job market. So for them, all right, if the land is taken, what alternative that government is going to give? All right, land for land, or land for money, or land for jobs. And all of this has been first-hand experienced by people, and they created a knowledge fund that took up the right relief and rehabilitation measures to be taken. To the political parties formulated a Relief and Rehabilitation Act, and then it was stamped by the Apex Court of our country. So what I'm saying is, law-making, people's opinion is very important, all right? And without people's opinion, law-making cannot take place. So as academic, one has to sort of look at the bottoms-up approach, all right, and not the top-down approach, to understand, to make our students understand the law-making process or the legal process, all right, and the challenges faced by various components at various stages by various communities in this law-making process. Second important aspect is policy challenge. All right, policy challenge is a major issue. For example, Article 21A, all right, has been included in Part 3 of the Constitution, which guarantees right to education, RTE, for students from children from 6 to 14 years of age. All right. Now, this is the constitutional amendment that's been brought about. The significance of this constitutional amendment has also been highlighted by the court and the legal community, by the judges, by the lawyers. All right. Now the policy has to be implemented on the ground. All right. And for that, a framework is required. Policy framework is required. Now, I mean, I am sorry to say that Article 21A is not, I mean, in the way it is being, the constitutional amendment is being brought about, is not fulfilling either the intent of the legislature or the objective of the constitutional amendment. Alright, so policy, legal framework is perfectly alright, but to translate that legal framework into policy issues is a real challenge in this country. Alright, and one of the reasons that I have identified is institutions in this country have become so unworkable, all right, that some institutional overhauling is required, all right, so that the institutions can deliver the required result as intended by the legal community, as intended by the policy community, all right, as intended by by the judges, honorable judges of the courts and the lawyers, all right. So one of the challenges in terms of implementing the policy is the institutional overhaul, all right, and that institutional overhaul is the need of the hour. That's what I would say. So there are significant sort of academic and policy level challenges insofar as implementation of the laws are concerned. Thank you.
Thank you, sir, for explaining the critical role of research in bringing the policy gaps. Your suggestions on addressing these challenges resonate deeply. Moving ahead, let us now explore how legal profession can collaborate with the civil society. Achieving the social justice is not solely the government responsibility. Collaboration between the lawyers
evolving. So many factors such as demographic changes, emerging social issues and regional disparities, they come into play, and there are many laws which need to be reformed or expanded to come into the system. Like when we talk of the reservation system in the education, the government jobs was designed to initially uplift the historically disadvantaged communities, the scheduled castes, the scheduled tribes and the other OBCs as we address them. However, in some regions and sectors, this system has come majorly under scrutiny for perpetuating a caste-based division. So the reform which might help to evolve it is like to introduce a more flexible and dynamic system of affirmative action. So the socio-economic criteria, in addition to caste, would help. This would also target the economically weaker section, the EWS, across all communities, and ensure that the benefits are not extended to the most marginalized, but also those who are in need, regardless of their background. So another aspect is the gender equality. So India as a country has made substantial strides in gender equality with laws in place against domestic violence, sexual harassment, like all these laws of POSH, DVAC, POXO. So they help for against the discrimination. But the enforcement is very weak in many areas as primarily deep-rooted patriarchal norms. They continue to hinder the progress of such laws. Like the laws are there, but how to implement them becomes a very questionable fact. And as Professor Maheshwar also said that laws are not merely there for the society, it is like the three limbs, as we say, the administration, the judiciary, the legal society, everybody has to act in tandem for the enforcement. So these reform I would say for gender equality would be to strengthen the enforcement of the existing laws. Laws are very much there. And better protection for mechanism for girls and women, especially in the rural and marginalized communities. Sometimes they do not even report if there has been an infringement. There is no need felt by the marginalized communities to take it out open. Now, when we talk of domestic violence, there is such a big backlog that many a times, generally females who have suffered a domestic violence, they are thrown out of their in-laws' house. But for 2 years, there is nothing which moves forward only in their initial petition. So that becomes, an impediment. It's like a stumbling block because there is a law in place, but the implementation is delayed to an extent that it's wrong. Sorry? I think somebody's audio is on. So anyways, Coming to the third aspect, so the rights of the minorities and the religious groups, India we know is it's a diverse country, it's a secular country, and there are various, we have a country where there is a desert, there are mountains, it's like the landscape is often, which also adds to the tensions faced by the people staying over there. So the constitution though guarantees equal treatment for all, but sometimes the rights of the minorities, they are under a threat, and the discrimination based on religion and the caste division.
The judgments of the Supreme Court made from time to time, the implementation is required, and that will be a cause of social justice if the government wants, if the people want, or somebody who is interested in the peaceful atmosphere, then the implementation is necessary. Now, what is the implementation? I am coming to the judgment of the Supreme Court just for two lines where it has been stated that the Supreme Court in Singh versus State of UP has stated that now let us consider the scope of Article 21. The expression life used in that article cannot be confined only to the taking away of life, causing death, and much has to be done. That is something more than animal existence. The inhibition against its deprivation extends to all those limbs and faculties by which life is enjoyed. The program is waiting for me, and now I thank you very much. This means physically, then you will call me.
Sir, it will be a humble request. Mr. B.K. Yadav sir would be giving a vote of thanks.
Okay.
Sure.
Guest panelists, Honorable VC sir, respected director sir and attendees, on behalf of Uttarakhand International Business School, it is the immense gratitude and appreciation that I extended a heartfelt vote of thanks for our participation in today's panel discussion. The topic was Indian Constitution and Social Justice, Issues and Challenges of the Laws, Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Sakshya Adhiniam. First and foremost, I express my deepest gratitude to Honorable Mr. Justice Rajesh Tandon ji, former judge of the Uttarakhand High Court, for his invaluable insight, experience on judicial prospect and constitutional interpretation. Your throughout observations have greatly enriched our understanding of the interplay between the justice and constitutional mandates. Thank you very much, sir. I would also like to thank Mr. Anupam Goyal, sir, Judge of the District and Session Court, Muzaffarnagar, UP, for sharing his practical wisdom and on-ground challenge in ensuring justice within the framework of evolving legal system. Your contributions have shed light on the real-world application of the laws under the discussion. Thank you very much, sir. My heartfelt thanks to Ms. Puja Anand, an internationally accredited mediator and advocate, for emphasizing the significance of alternative dispute resolution mechanism along with the justice system and bringing a fresh perspective on the role of mediation in addressing social justice. Your expertise in bridging legal framework and human concern has been greatly commendable. Thank you very much, ma'am. A special thanks to Professor Dr. Maheshwar Singh ji from the National Law University, Delhi, for providing an academic and policy-oriented overview of the topic. Your detailed analysis and excellent approach have helped us to decide the real meaning of the Constitution and how it should be used along with the broader legal and societal framework. I would also like to thank all the attendees, students, faculty members, legal personality, who have joined us today. Your presence and engagement reflect your dedication to understanding and addressing the critical issues surrounding the Indian Constitution and social justice. Finally, I extend my sincere appreciation to the organizing team at Gitarathan Business School for their hard work, seamless coordinations in making this event possible in the online mode. Let this discussion be a stepping stone towards constructive dialogues and prospective action in upholding the value of inherent in our Constitution. Thank you once again, and we look forward to your continued support and participation in future also. Thank you very much, all of you.